minutes.
She's waiting for people to come in.
We'll start in 2 minutes.
क्या करते हैं सारे होते काम
Good afternoon, everyone. I welcome you all to the third national webinar conducted by the Lawsters on the topic Delving into the Legal Space, Righteousness and Values in the Legal Profession. I'm Riya Kumari, the moderator of this program, and I hope that at the end of this webinar, you will all well informed on the subject of our theme. I want to inform you all that this webinar is currently being streamed on two platforms, Zoom and YouTube Live. Our Zoom streaming and YouTube Live audience primarily consist of all the Zoom students from various universities of our country and people connected from the legal professions and fraternity. For the purpose of this webinar, I request you all to please note that our audio lines are on mute, and I request you all to ensure the same for the rest of the event. Lastly, please keep an eye on the chat box for constant updates regarding the attendance and Q&A round. I hope you all are clear with the instructions mentioned. Giving a brief about our platform, the Lawsters is a web startup by a group of law enthusiasts from several law universities of the country. Our venture aimed to provide a platform for the benefit to the legal profession and to the society. We utilize our stage to address happening of law and talk about the contemporary legal issues. Elaborating on the theme of our third national webinar, we wish to provide the audience, the legal fraternity and law students with the pathway of legal profession and talk about its values. Doing justice to our idea, we have our esteemed speaker, Senior Advocate Indira Jaising, former Additional Solicitor General of India and founder of the Leaflet. In the last 60 years, Senior Advocate Indira Jaising has been at the forefront of the public interest and civil rights litigation in India. She is noted for her legal activism in promoting women's issue, human rights cause, and environmental issues, among others. Ma'am, the entire team of Lawsters is extremely grateful and pleased to have you in this event with us. We also have with us Advocate on Record at the Honorable Supreme Court of India, Mrs. Nanita Sharma. She has been practicing as an advocate since 1988 and is an advocate on record in the Honorable Supreme Court since 1995. In 2013, she was nominated by then Chief Justice of India as an ex officio member in the Supreme Court Legal Services Committee via official gazette notification and remained member till 2013. She has been appointed as a mediator by the Honorable Supreme Court, which possession she is still holding. She has taken up many social causes and has filed many public interest litigations involving social and environmental issues. We have this pleasure of having her as our member of the advisory board of the Lawsters. She is our pillar of strength and is always guiding us in our journey. Without her, the event and having Indira ma'am with us would not have been possible. Indira ma'am and Nanita ma'am, the entire team of Lawsters is hereby grateful by your presence today and choosing to grace our audience with this enriching experience despite your busy schedule. I now request Nanita ma'am to take the forum and say a few words about Indira ma'am. Ma'am, kindly unmute yourself.
Oh, I'm
Yes, ma'am.
Thank you, Riya. Really privileged to be here today and a part of this webinar. Indira Jaising is a name which really needs no introduction. Sincerity and integrity are two adjectives that very well describe her. Ian Campbell has said, I quote, "In order to succeed at anything, one must be dedicated." Most lawyers are. If we want to have a thriving, buzzing office that will stimulate us and our staff, then we must develop the philosophy that in order to produce unusual results, we sometimes must use unusual methods. We must develop a passion for what we do, a real burning desire to help the client in whatever field of law we practice. Indira Jaising ji is an epitome of passion, who has a real desire to help not only her clients, but also all those who are in need of any help in society at large. As she believes in, we take so much from society, we must return. Indira Jaising ji was born on January 3rd, 1940, in Mumbai to a Sindhi Hindu family. She did her school education in Mumbai and completed her Bachelor of Arts degree from Bangalore University. In 1962, she completed her LLM and got a postgraduate degree in law from University of Bombay. She started her practice in the early 60s. In 86, she became the first woman to be designated as a senior advocate by the High Court of Bombay. In a close to a 60-year-long career, she is noted for her legal activism in promoting human rights causes and has distinguished to have been at the forefront of public interest and civil rights litigation in India. A keen environmentalist, Indira Jaising ji has argued major environmental cases in the Honorable Supreme Court. She has argued several cases relating to discrimination against women, including Mary Roy's case, which led to the grant of equal inheritance rights for Syrian Christian women in Kerala. She has represented Rupan Deol Bajaj, the IAS officer who had prosecuted KPS Gill for outraging her modesty. This was one of the first cases of sexual harassment successfully prosecuted. She has also argued the case of Geeta Hariharan, in which the Supreme Court in a bench presided over by the then Honorable Chief Justice A.S. Anand held that under Hindu law, the mother was also the natural guardian of her minor children, and hence the children could also bear the name of the mother. She has also successfully challenged the discriminatory provisions of the Indian Divorce Act in the High Court of Kerala, thus enabling Christian women to get a divorce on the ground of cruelty or desertion, a right which was earlier denied to them. She has represented Teesta Setalwad in a case where she was targeted and accused of embezzling money. Indira Jaising ji has represented the victims of the Bhopal tragedy in the Supreme Court of India in their claim for compensation against the American multinational Union Carbide Corporation. She has appeared for Air India employees in the case of Air India versus Union of India, seeking equal pay for equal work for women. She has even fought for labor rights and argued against eviction of payment dwellers of Mumbai and their loss of livelihood. In 2015, she fought tooth and nail, demanding due process for the Greenpeace activist Priya Pillai, who was disallowed by the Government of India to travel to London and depose before a British parliamentary committee against a UK-registered coal mining company in 2015, thus defending a citizen's fundamental right of freedom of expression. It is in this context that her keen interest in ensuring the independence of judiciary, one of the three pillars of democracy, must be seen. Hers is a distinct and discerning voice that must be heard to make sense of these troubling times. Indira Jaising ji's role was pioneering in forming landmark laws against domestic violence, against sexual harassment at workplace, among other legal interventions. She has been associated with several people's commissions on violence in Punjab to investigate the extrajudicial killings, disappearances, and mass cremations that took place during the period 1979 to 1990. The United Nations appointed Indira Jaising ji and two other experts to a fact-finding mission investigating alleged killings, rape, and torture by security forces against Rohingya Muslims in Myanmar's Rakhine state. In 2016, in Indira Jaising versus Supreme Court of India, Ma'am challenged the procedure for designating senior advocates in the Honorable Supreme Court. Indira Jaising ji has attended several national and international conferences on women and represented her country at these conferences. She had a fellowship at the Institute of Advanced Legal Studies, London, and has been visiting scholar at the Columbia University, New York. She was a member of the United Nations Committee on the Elimination of Discrimination Against Women. She has been conferred with the Rotary Manav Seva Award in recognition of her services to the nation in fighting corruption and as a champion of the weaker sections of the society. She was given the Padma Shri by the President of India in 2005 for her service to the cause of public affairs. Her partner, Mr. Anand Grover, is a noted human rights lawyer and designated senior advocate of the Supreme Court. In 2018, she was ranked 20th in the list of 50 greatest leaders of the world by Fortune magazine. She is the founder of the legal blog, The Leaflet, where she authors various legal opinions and actively engages in spreading the principle of constitutional morality and the rule of law. Indira Jaising ji has traced a long and eventful journey and made her mark as an outspoken and intrepid legal interventionist who is not afraid to call the spade a spade. Most welcome, ma'am. Over to her now.
Thank you, ma'am, for the kind introduction. Now, beginning our webinar, I would now like to give the forum to our esteemed speaker, Senior Advocate Indira Jaising, and enlighten the audience with her scholarly deliberation.
Thank you, Ria. Thank you, Nanita, for that extremely generous introduction. I'm speaking here to an audience of law students, and therefore, and I'm told lawyers as well. And therefore, I have chosen for today's discussion the nature of the legal profession, its role, its challenges, and its limitations. Many of you have had occasion to enter the courtroom, either as students or as practicing lawyers or as litigants. The first thing that you must have noticed is the motto of the courts, Satya Meva Jayate. This should give you a clear idea of the respective roles of the court and of lawyers. In fact, if one leaves it at that and says no more, it should actually set you on a journey to find out for yourself what exactly is the role of the legal profession within this context, within the context of the motto of the courts. Central to the role is the purpose of the institution, which is to serve the seekers of justice. Mark my words, the seekers of justice come to court. No one walks into a court voluntarily. They are either in a dispute or they want relief, seeking what they consider to be justice, or are summoned to the court as accused persons. In either case, courts exist for them. Courts are conflict zones, and we as lawyers, through our efforts, convert these conflict zones into resolution zones, conflict resolution zones. But the central quest remains to ascertain the truth. However, we can never be sure that what the truth is, since we as lawyers were not eyewitnesses to the events we talk about. Hence, our task is a very difficult one. On the one hand, there is a tendency to completely identify with the person we represent and believe the version presented to us. On the other hand, the function of truth finding is that of the court and not ours. This puts us in a situation in which we are required to be dispassionate about our work. But being dispassionate about a case is not the same thing as being dispassionate about the quest for justice. The quest for justice, equality, and non-discrimination is what the lawyer's role is about. And without this quest, our role is meaningless. In his iconic book, How to Kill a Mockingbird, the lawyer Atticus Finch says, and I quote, while unfortunately all men are not born equal, there is one way in which men are treated as equal. There is one human institution that makes a pauper equal to a Rockefeller, the stupid man equal to an Einstein, and the ignorant man equal to any college president. That institution, gentlemen, is the court. Our courts have their faults, but in this country, meaning the USA, our courts are great levelers, and in our courts, all men are treated equal. Close quote. This, I am sorry to say, is an ideal, but not necessarily the situation that we find in our courts. We are not necessarily all equal in court. Bias, blind prejudice, lack of access to legal services all make us less than equal. Let me just give you the profile of a litigant. All manner of people have reason to approach courts. A tenant seeking to prevent eviction by a landlord, a couple seeking divorce, a commercial contract which has been breached, or a claim making the government accountable for violation of human rights, fundamental rights. To prosecute crime is the exclusive privilege of the state. And several people find themselves arrayed as accused persons in a court of law. They, more than anyone else, need lawyers since they run the risk of losing their liberty. Now, let me say a few words about who is the largest litigant in court. But who is the largest litigant? It is the government of the state or the Union of India. They are often arrayed as respondents in writ petitions for violations of laws and fundamental rights. In the case of criminal law, it is the state which has the exclusive privilege to prosecute all crime. The fight of an individual against the might of the state is always an unequal one. Our courts have a theory of presumption of constitutionality of all acts of government, which determine often the outcome of a case. We have seen this happen more particularly during this pandemic, which has spread fear, causing us to accept draconian measures such as lockdown, presumably in our own interest. It is not my case that no lockdown should have been imposed, but the manner of imposing the lockdown could have been lawful and constitutional and well thought out. We have seen how, with less than 8 hours' notice, millions of interstate migrant workers were rendered homeless without any right to food and had to walk more than 1,000 kilometers to what they consider to be their homeland. Images of these migrants dying on railway tracks are still fresh in our mind. They too are citizens and seekers of justice. What is the lesson we learn from this? Emergencies of all kinds challenge our commitment to the rule of law, and a pandemic is also an emergency. But at times like this, we need to remind ourselves firmly of the commitment to the rule of law. Atticus may have been wrong when he suggested that we are all equal in court. Let me say a few words about the origin of the legal profession. India inherited its judicial system from the British. And since then, it has evolved to have a constitution of its own which allows for an impartial and independent judiciary. The open court system is a tradition of the English courts in the common law system, which we adopted, which means that either that justice must not only be done, but also seen to be done. We should all be allowed to enter the courtroom. It is a system of public trials. But let me remind you that this was not always the case. Justice was done in secret chambers, which were known as the Star Chambers. The chambers were constituted under the Star Chambers Act of 1487 and was a supplement to the common law of England. The Star Chambers drew their authority from the king, the sovereign power and privileges, and was not bound by any rule, regulation, or constitution. The Star Chambers were the judge, jury, and the executioner. There was no question of legal representation. And if you talked about having a lawyer to defend you, you would have been laughed at or probably picked up and tried in the Star Chambers and done to death. Now, from there, we come to the development of British justice in India. At first, the mayor's courts were established in 3 presidency towns. They were the Crown's Court. The right to appeal was to the Governor General and Council, and from there to the Privy Council. It was in 1791, foreign judges felt the need of experience, of local experience. And that is when the rule of allowing an attorney to protect the right of the client was upheld in the mayor's courts. You can see, I suppose, the emergence of a legal profession. What you must remember is always the birth of the legal profession for you to understand what your role as a lawyer is. Now, the Supreme Court of Judicature was established by Royal Charter in India in 1774. The Supreme Court was established as there was dissatisfaction with the weaknesses of the courts of the mayor. The first barrister who appeared in India after the opening of the Supreme Court in Calcutta in 1774. As barristers began to come into the courts on work and as advocates, the attorneys gave up pleading and worked as solicitors. You find the bifurcation of the legal profession happening. This distinction is partly reflected in the Supreme Court of India in the distinction between advocates on record and senior counsel. But advocates on records are not debarred from arguing in court. The charters of the court stipulated that the Chief Justice and the 3 puisne judges of the English barristers must have at least 5 years standing. The charters empowered the court to approve and admit and enroll advocates and attorneys to plead and act on behalf of litigants. I hope you're getting the link because we'll come down to 1961 when the Advocates Act comes to be passed. The charter empowered the court to approve, admit, and enroll advocates and attorneys. They also gave the courts the authority to remove lawyers from the role of the court on reasonable cause and to prohibit practitioners from being admitted and enrolled as advocates of the court. The court maintained the right to dismiss any attorney for an act of misconduct. Attorneys are not admitted without recommendations from any other officials. In 1862, the High Court started by the Crown were established in Calcutta, Bombay, and Madras. The High Court bench was designed to combine the Supreme Court, the Sadar courts, and the Mayor's courts traditions. This was done to unite legal learning and judicial experience of the English barristers with the innate experience of civil servants and of local Indian lawyers, customs, and usages. Each of the high courts was given the power to make rules and qualifications for proper persons, advocates, vakils, and attorneys to be admitted to the bar. The admission of vakils to practice before the High Court ended the monopoly of the barrister in the Supreme Court. It greatly enhanced the practice and privileges of Indian lawyers by giving them opportunities and privileges to appear before English judges. Now, the Indian Bar Councils Act came to be passed in 1926 to unify the various different types of practicing lawyers under one category of lawyers. The Act required that each High Court must constitute a Bar Council made up of Advocate General and other advocates whose names would be recommended by the High Court, and those who would be elected by their peers. The duties of the Bar Council was to decide all matters concerning legal education, qualification, and enrollment, discipline, and control of the profession. It was favorable to the advocates as it gave them authority previously held only by barristers. Finally, you've got the Advocates Act of 1961, which was a step further. It constitutes an all India bar, and it sets out rules, regulations, ethics of the profession, what constitutes misconduct, what does not constitute misconduct. So the right to legal, this is the point actually of telling you this long story. The point is to tell you that the right of legal representation has emerged with the rejection of the Star Chambers, and hence one must never forget that it arose out of the need to protect life and liberty. This is why I say lawyers are the frontline defenders of human rights all over the world. Our role is to defend the rule of law. Now, this, of course, brings us to the question, what is the rule of law? The rule of law is distinguished from the rule of tyrants, from the rule of authoritarians, leaders, from the rule of fascists, from the rule of monarchs, which brings you to the rule of democracy. And this is what sums up the rule of law, quote, "Be you ever so high, the law is above you." The rule of law is also captured in the basic features of the Constitution of India. The preamble, the fundamental rights, democracy, liberty, secularism, and federalism are the basic features of the Constitution. We are all bound by it equally. Governments, citizens, judges, lawyers are all expected to bring their actions in alignment with the basic features of the Constitution of India. Our newfound liberty, barely 73 years old, must be fought for and maintained by our vigilant actions as lawyers and as citizens. Majoritarian governments tend to threaten this framework of law, insight, justice, and justice and governance. We have all heard the argument that once we elect our representatives, what they do represents the will of the people. But the will of the people, but the buck doesn't stop with the will of the people or with the representatives that we elect. There is the basic features theory, and there is a Supreme Court and our high courts which look into the actions of those who say that they represent the will of the people. But the disproportionate presence of the poor people in jail, the killing of Black people in the United States of America by the police, the disproportionate number of minority communities targeted by lynching on the streets of India for alleged violations of law and order, all remind us that we have not been able to live by the rule of law. Rather, we seem to be living by the rule of the mob. So if you were to ask me what were your challenges in the times to come, this would be one of your challenges. How will you defend the rule of law? How will you dismantle the rule of the mob? There are no easy answers to this question. This should lead us to think, is our constitution being endangered by attempts to destroy its secular nature? In my opinion, the answer is a clear and categorical yes. And as I said, our challenges moving forward are to defend the rule of law. Now, let me come to saying a few words about independence of the judiciary and of the legal profession. First, I want to tell you that there can be no independence of the judiciary without the independence of the legal profession. Uh, we know a lot and we talk a lot about independence of the judiciary, but we don't talk about the independence of the legal profession. Independence of the legal profession from whom is the question. Now, I have an answer. You may accept it, you may reject it, but the answer is that lawyers must primarily be independent of judges. Independence from judges. Independence of the judiciary has been guaranteed under the Constitution by the doctrine of separation of powers, where the executive is not supposed to have direct access to the judiciary. They're completely separate institutions. There are institutional frameworks in place to make that separation happen. But there are no independent frameworks in place to make the independence of the legal profession from the judiciary happen. Judges, of course, take an oath when they assume office to do justice without fear and favor. Remember, lawyers don't take any oath when they enter in their legal profession. We lawyers stand here in court as a barrier between the executive and the judiciary, so to say. Why? Because our system of justice is an adversarial system. Tell me, can any of you visualize a court without lawyers on both sides, for and against a person? Impossible. So therefore, which institution stands between the judiciary and the executive? It's us lawyers. And therefore, our independence must also be guaranteed. Now, once you understand this clearly, that lawyers must be independent of judges, one can go on and on and on giving you any number of examples, but I would prefer that you think this issue through for yourself. Just bear with that concept that we have to be independent from judges. Now, how do we become independent from judges? We become independent from judges by guarding very strongly our right to make bona fide criticism of judges. The judiciary itself must function as in a transparent manner and be willing to accept bona fide criticism from lawyers, because we are stakeholders in the business of dispensing justice. What would happen if the executive had direct access to judges without lawyers? Okay, we would be back to the days of the Star Chambers, where there was no distinction between the executive and the judiciary, no lawyers to defend the accused. Judge, jury, and executioner would be the same person. We would lose our commitment, constitutional protection of innocent until proven guilty. We would lose the protection of the distinction between the judiciary and the executive. And therefore, I come to the question, what are the threats to the independence of the legal profession? In my opinion, one of the largest threats, or the emerging threats to the independence of the legal profession, is the power of contempt of court. I'm not going to dwell extensively on what happened to Prashant Bhushan, but it must be an eye-opener for all of you. Contempt of court, unfortunately, the biggest threat to the independence of the legal profession has come from the judiciary itself. The judiciary has claimed the right and the power to punish lawyers for contempt of court outside the framework of the Contempt of Courts Act. We all know that freedom of speech is subject to reasonable restrictions, and contempt of court is one of those reasons to restrict free speech in a reasonable manner. However, in the case of Prashant Bhushan, the court exercised the power to convict for contempt, dehors the Contempt of Courts Act. It claimed an inherent power to convict for contempt of court. In my opinion, this is a violation of the basic principle of constitutionalism and the rule of law. Namely, what is this principle? That fundamental rights can only be restricted by law, not by the judiciary alone. And therefore, the Supreme Court abandoned abandoned the Contempt of Courts Act, fell back on its inherent power to convict for contempt of court, and that, in my opinion, is what constitutes the biggest threat to the independence of the legal profession. And unless we work unitedly to undo these precedents, we have not entered a slippery terrain. We have been led into a ditch. We have been led into a cul-de-sac. We have been led into a tunnel. And we need to see the light at the end of that tunnel. The light at the end of that tunnel can only be an undoing of the two judgments of the court, one of conviction and the other of punishment. In order for the legal profession to perform its true role, they need to be independent of judges. By this, I mean they need to be respectful of judges, but not sycophants. Lawyers who bend over backwards to please judges pose the biggest threat to the independence of the judiciary. They make it possible for judges to do what they want to do. They make it possible for governments to get their job done through a walkover directly to the court without going through the constitutional scheme of legal representation. The threat of contempt of court has emerged as one of the biggest threats to the independence of the legal profession and therefore the independence of the judiciary. Now, a few words about the right of legal representation. The rule of law requires that we have an independent judiciary and a profession, and the right to legal representation is a guaranteed fundamental right. Much has been written about independence of the judiciary, but not enough about independence of the court. We are given a fancy name, officers of the court. But in a republican democracy, under a written constitution, there can be no administration of justice without litigants being represented by lawyers. We have what we call an adversarial system, and therefore the right to be represented by lawyers. A fundamental right is also guaranteed under Article 39A of the Constitution of India, and we know now that legal aid is a fundamental right. Article 21 guarantees to us the right to life and liberty, but it has no meaning because it says no person shall be deprived of life and liberty except by procedure established by law. And for the procedure established by law, we need to go to a lawyer who will represent us. This is what the guarantee of life and liberty means in real terms: the right against self-incrimination, the right to be represented by counsel. The burden of proof in criminal proceedings is on the prosecution, the right not to be tortured. In most constitutional courts, the state is, of course, the prosecuting agency. We all know that. The law enforcement arm of the state, the police, are often the biggest lawbreakers, and in most recent times, they seem to depend upon the faithful press to defame accused person well before the innocent have been proved guilty. Press conferences by the police during the pendency of a case are highly questionable and can amount to prejudicing administration of justice, and I suggest would amount to contempt of court. We are innocent until proven guilty. That I think even a first-year law student knows. Lawyers, therefore, have a major role to play in the defense of the people against the might of the state. I'll say a few words about the collective legal profession. Can we fight this battle alone? No. We need to fight it collectively. An attack on one lawyer is an attack on the entire legal profession. And I'm talking about principled attack. I'm not supporting lawyers who may be corrupt. I'm not supporting lawyers who let their litigants down. I'm talking about lawyers who stand up and speak truth to power. This must be defended collectively. Uh, when I talk about collectively, I mean through our respective bar associations and through our bar councils. They must not be associated with the executive. And yet, in recent times, we have seen the Bar Council of India issue a statement in relation to Article 370. Quote, the Bar Council of India wholeheartedly congratulates the Union government on the historic and landmark decision to scrap Article 320 of the Constitution of India. This step should have been taken only by a bold, magnetic, daring, unparalleled leader like Modi ji, being ably supported by other dynamic leaders like the Home Minister, Shri Amit Shah ji. This step is a clear proof of the wisdom, foresightedness, dynamism, and courage of the Honorable Prime Minister. Close. Now, all of this may be true, but should it come from the mouth of the Bar Council of India? Or would you say that in making a statement like this, they have lost collective independence of the legal profession? My answer is yes. You're welcome to hold your private views that this statement is true. But when you venture to represent a collective, then a distance has to be put between the collectivity of lawyers and the executive to safeguard the independence of the legal profession. Now, let me talk about the challenge of individualism. The biggest challenge we face is the challenge of individualism. Our human rights issues, the Bar Council has failed to act collectively, and our bar associations have also failed to act collectively. There is, however, a very small silver lining, and that is that in the recent times, when there was an attack on Prashant Bhushan, we did see lawyers coming together and working in defense of the right of free speech. But we need to see more bar associations speaking up on the issue of human rights and having their own human rights committees which can interact with Parliament and which can interact with the judiciary. I come now to our individual challenges. One of our individual challenges is in independence of thought, and some of it is reflected in what we have known as the cab rank rule. Now, the cab rank rule says that every lawyer is bound to accept every brief that comes their way. I have often found myself challenged in the face of this rule. Because as Nanita pointed out in the introductions, I have made my choices. I have worked for gender justice. I have worked for the right to health. I have worked for the rights of the LGBT community. I have worked generally in the field of human rights. What happens if a rapist were to come to me and say, please defend me? Now, I know that according to the cab rank rule, I am supposed to represent that person. And let me tell you that all of you will be called upon to represent a client one day or the other, which will challenge your individual conscience. How will you take those decisions? I really don't know. In my case, I took my decisions depending on the role that I played, not as a lawyer, but as a public intellectual. As Nanita pointed out to you, I have worked not only inside the courts, but even outside the courts. And in my capacity as working outside the court, I worked with the Lawyers Collective, which is an organization which I founded. And it's an organization of lawyers which works pro bono, but it also works at the policy level. As an organization, we drafted and got success in getting a law passed by Parliament known as the Protection of Women from Domestic Violence Act. We were also successful as an organization through my partner, Anand Grover, who incidentally also was the special rapporteur for the highest attainable standard of health at the United Nations of an anti-discrimination HIV law. We were single-handedly credited with having drafted this law through a consultative process, and very few people know that it's still today the single and only anti-discrimination law in the country. We don't have an anti-discrimination law for women. We have a constitutional guarantee, but not an anti-discrimination law. We have an incipient anti-discrimination caste law in the Protection of Civil Rights Act, but not a full-fledged law. But we do have a full-fledged law which prevents people from discriminating against people with HIV. And who knows, in the future, we might also need a law to prevent people who get the coronavirus from being stigmatized. I can tell you that I have recently emerged from being infected by the coronavirus myself. I was one of the lucky ones. I was repeatedly told, ma'am, look at your age. Don't you think you should be entering a hospital instead of being at home? And I resisted all these attempts. I got messages from the legal profession. I got messages from law students. I got enormous support telling me, you are a fighter and you will come out of this. You will not allow a virus to defeat you when you have not allowed so many larger forces to defeat you. I would like to publicly acknowledge my debt of gratitude to my fellow travelers in the legal profession, as also among students, for having supported me and my partner through the period when we were corona positive. Today, we are negative, but we are at the stage of recovery. But the reason I brought this up is because I wanted to share with you that we hope that people who had corona will not be stigmatized in the same way in which people with HIV were stigmatized. Hopefully, the world has learned its lessons. Hopefully, the world is moving towards a scientific temperament, which is also part of our duties. So, having talked a little bit, I have spoken to you about several issues. I have spoken to you about my personal challenges. I have spoken to you about the collective challenges of the legal profession. I have spoken to you about the individual challenges of the legal profession. And I have spoken also to your conscience. And I have alerted you to the fact that soon you will be called upon to make the kind of choices which I had to make. I know that there are many examples I can give you, but I prefer to do that on a one-on-one basis. If any of you are interested, I can reach out to you and share with you the dilemmas that I faced and how I resolved them. But I want to tell you one thing, and that is that we at the Lawyers Collective, me and my partner, have paid a very heavy price for speaking truth to power. We have been victimized. We have been victimized by the power that be. We have, in 2015, we were slapped with an FIR, and I firmly believe that the only reason that we were slapped with this FIR is because of the work that we did. When I was ASG, was called upon to argue the case of Union of India in the Surabuddin case, where one of the accused in the case was our current Home Minister. He was then the Home Minister of the state of Gujarat. I have also argued the Justice Lohia case. My partner went to court when the Home Minister was discharged by a Bombay court, challenging the discharge. At a time when 15 seniors refused to represent Yaqub Memon, Anand Grover was approached and he regularly agreed. And for that, he has been called anti-national. And I have no doubt that this FIR, which has been filed against us, has been filed to silence us. I'm not the only one to whom this has happened. Today, it is lawyers who are under attack. It started with me, maybe even before me, it started The attack came on Tista Setalwat because she took cases to court against the Modi government when he was the chief minister of Modi. It happened to me because in my capacity as ASG, I was arguing these cases. It happened to Anand because he represented Yaqub Memon. He represented him on the issue of the death penalty, because every person is entitled to a legal defense. It's happening today to those who stood up protesting against CAA, defending the secular fabric of the Indian Constitution. My hope is that you, lawyers and law students, will rise to the defense of people like me. And I say people like me, people like me, people like Tista, people like those who have been picked up in the Delhi riots for no fault of their own, except that they demonstrated in a lawful manner. And I have only one last concluding comment to make to you before I stop and hand back the mic to Ria and to Nanita. And that is that Nanita will tell you that despite these attacks, my dear, we have only one way to live, and that is to get up, and stand up for our rights. And this is the reason why I have joined hands with Nanita. I'm very fond of her. I love her in defense of the students of Jamia. All of you have seen the videos in which the police marched into the university, walked into the toilets, and beat up students. Yeah. She has taken the case to court on behalf of the students, and she was kind enough to engage me as a senior counsel, and we're working together. I hope that this sends a message loud and clear to the government that, yes, you can file FIRs against us. Who knows? I don't know where that case is going. I know that I have been accused of, as Tista was accused, of misusing FCRA money, of violating FCRA, of not keeping proper accounts, of cheating, of fraud. You call it what you like. As somebody said, you show me the person and I will show you the law. Not the other way around, that you show me the law and I will tell you what should be the outcome. This is the situation in which the vast majority of us who still live by our conscience are being treated. And so I stop here with a call to law students, with a call to action to the legal profession, namely rise in defense of human rights defenders and become a human rights defender yourself. Thank you very much for giving me this opportunity.
Thank you so much, Indira Jaising ji, for such an enlightening address. I was really getting goosebumps while listening, and I'm sure all of you also must be experiencing the same. You have rightly said that only seekers of justice reach the courts, and we as lawyers don't need to be dispassionate about our work, but we cannot be dispassionate for the quest for justice, equality, and non-discrimination. You have rightly said that the lawyers have to be committed to the rule of law. Our role as lawyers is to defend the rule of law, the basic structure of our constitution. You have rightly said that the lawyers must be primarily barriers between the judiciary and the executive, and hence our independence should be guaranteed because we are the stakeholders in the business of justice. Thank you so much, Indira ma'am, for your kind words and the words of wisdom. We have surely been honored and privileged to hear them. Now, I would just like to conclude by adding a few words myself. If Ria, do I have your permission?
Yes, ma'am, sure, ma'am.
Thank you, Ria. So life is spent in meeting challenges. Situations and problems continue flowing towards us. We do not have to look for them. How do we deal with them is what matters. And to meet them efficiently is the game. Sometimes we win, sometimes we lose. But meet them we must. There is no choice. However, there is one choice that we all have, which is completely in our hands, and that is not doing anything in our lives at the cost of our conscience, our moral values, our principles. And for that matter, even if we seem to be losing materialistically at any point of time in life, we actually have won because we have not compromised with our values and what we believe is right. For that, we need to be very strong and have to have an inexhaustible strength. Hence, we need to be strong, not merely with the physical strength of a bull, but the subtle vitality of a calm mind, diligent in its application, consistent in its logical thinking, and replete with a will to win over all negative tendencies that poison and weaken the mind. Be steady at the helm of truth. Be pure as you were at the time when you were born. Gaze self-ward and proceed full speed. Keep smiling, accept adverse criticism, do not get perturbed. Words are but disturbances in the air, created by merely moving the tongue. If there is nothing true in the criticism, ignore it, all as meaningless chatter. If there is truth in it, accept it with gratitude and bring about the necessary changes in yourself. Thus improve and come to shine more than ever before, and be grateful to all your creative critics. Thank you all so much. Thank you, Ria. Thank you, ma'am, for those wonderful, wonderful words. And we look forward to seeing you again on this webinar. Thank you so much.
Thank you,
And
ma'am.
thank you, lastly, thank you all the audience.
Thank you, ma'am. Thank you. Thank you, Indira, ma'am. Thank you, Nanita, ma'am. This was truly very informative and eye-opening for all of us. The speech was personally very awakening, which fills me with the pride of independence and inspiration. Indira, ma'am, you're an absolute role model to everyone who looks up to the career of advocacy and the legal profession. Absolutely, ma'am.
She's my mentor in the profession.
Yes, ma'am, totally. So, ma'am, keeping with the pace of our event, with your permission, ma'am, Indra ma'am and Anita ma'am, we will now address questions from the audience. Chayan, kindly take over.
Good evening, ma'am. Uh, so we are flooding, like our chat boxes are flooding with questions, but due to time restraint, we'll just take a few of them. So kindly, raise your hands and start asking the question. Okay, we have a question from Aman Rahman. Okay, Aman, I'm unmuting you.
Hi, good evening, everyone. At the outset, I would like to congratulate the Lawsters for hosting this amazing webinar, which was both eye-opening and goosebumping, as Anita ma'am already said. And thank you, Indra ma'am, for the thought-provoking and empowering speech, I would say, and not a lecture. So thank you so much for that. Now, I have a dilemma in my head when I ask you this question, which is personal in nature. So I'll just bore you with a minute of my background. Now, when I made up my mind to pursue law, I was hell-bent on following the corporate side of it. Even before I entered law school, I was determined that I have to join a corporate firm and make a quick buck. Right. With that, but soon after joining law, and especially after reading constitutional law, in the last 3 years, I've been a part of the legal aid committee and an office bearer of the same. Now, while, as you rightly said, upholding fundamental rights and representing the impoverished and downtrodden sections of the society are definitely the most satiating part of a lawyer's job and are definitely goosebumping. But there is a growing trend for young law school students, and especially those who are the first generation lawyers, of actually following the corporate path for basically two reasons. First is financial stability, and the second is security in the manifestation of stability. Now, how do, if I want to practice advocacy as the path as laid down by great lawyers like yourself, then how am I to be sure that I will be able to feed my own stomach?
Ria, I think ma'am is on mute. You'll have to unmute her, Ria.
Yes, ma'am. And I'm listening. And ma'am, kindly unmute yourself. Yes, ma'am.
Are you able to hear me?
Yes.
Yes, ma'am.
Okay. So this question is obviously an important one. It has been asked again and again and again. However, uh, I have to answer it at two levels. One is the individual and the other is the institutional. At the institutional level, I think you law students should get together and demand that juniors who work with seniors in advocacy must be paid a certain minimum salary. Secondly, of course, there are many seniors who do pay. And when you say, how will I feed myself? It really depends on the standard on which you want to feed yourself. As a beginner, if you want, you should be in a position to support yourself without being dependent on your family. This is a given. And in order to do that, when you work with a senior, you should be paid, even though you're a fresher and you're still joining the legal profession. But I can tell you that many lawyers who take to the corporate road soon get frustrated, soon realize that the pursuit of wealth is not giving them any satisfaction. I had a junior who started out life from a prestigious law school and who went into the corporate law. And within 6 months, he quit. And I don't know for what state and region he joined me. He could have joined anyone else, you know. I'm still wondering why he joined me because even at the time he joined me, which was some 20 years ago, uh, he should have known that I was working only in the field of human rights. Yes, but he got his basic training from me. Thereafter, he went on to establish a very, very thriving practice of his own. And I can tell you that I find myself very often in situations when many of my juniors have done much better than myself. And like a real guru, I feel that if your juniors do better than you, then credit goes to you. So there are two ways to handle this situation. One is yes, you work with a senior who's willing to pay you uh, a, a salary, not just a stipend. And I think maybe reasonable enough to be able. See, there is also the phenomenon of migration. You know, people come from all over the country to work in Delhi. So it depends. If you're working on your hometown, then maybe your needs are lesser. But if you're migrating from one state to another state, and women have this problem more acutely than a lot of other people. So we need to take up this issue at the institutional level and insist that there is a bar council rule for that matter. Instead of praising the executive, let them frame a rule saying that all seniors should pay juniors. And the second thing is, of course, like in the United States of America, those who are willing to do pro bono work should have their loans waived, and they should do a mandatory, say, 2 or 3 year period in pro bono work with law firms and then go on to earning their living. I hope I have answered your question. I can only tell you one last thing I'd like to tell you very, very clearly, and please understand it, okay? People ask me this question. Let me tell you, I get paid my fees, okay? I represent workers, I represent trade unions, I represent, as she told you, air hostesses. Yes, I obviously don't expect to be paid fees by homeless people, but there is a lot of work I do and even commercial work where I get paid. The only thing I don't do is work which is directly contradictory to human rights. So I don't think we can make any excuses for not entering the human rights domain.
Trayan, kindly take the next
Okay,
question.
okay, thank you, ma'am. The next question is from Kriti Sana. Kriti, I'm unmuting you. Just ask your question.
Just keep an eye on the time, please.
Yes, ma'am, we'll wind it up soon. Uh, okay, I think Kriti is not here. Shalvari, you have also raised your hand. I'm unmuting you. Kindly ask your question, Shalvari.
Good evening, ma'am. Firstly, I'd like to thank you for the enlightening session. I'm a fourth year law student, and my question is, what should a legal professional value more, the righteousness of law or the contention of client, keeping in mind the court, client, and conscience? Should an emotional connect with client be more valued than your own critical analysis of the case?
Try not to make a conflict between the two. It's always nice to have an emotional connect with your client, but you can have an emotional connect and yet be dispassionate about the case. Secondly, as a practicing lawyer, I have always advised clients, stick to the truth in your depositions. Uh, why? It's in your self interest. You're more likely to succeed when you tell the truth than if you manipulate the record and lie. Because judges are smart, they can see through a web of lies, that they're trained to do that. Yeah. So if a lawyer is going to manipulate the client and say, look, why don't you just slip this in and slip that in, you're going to lose your case. Okay. So this is how I resolve the conflict between my emotional connect. Many of my clients are my best friends. And my ability to present the case to the court as an officer of the court. I do not present propositions of law which are untruthful. The law is an open book. You've got all your SCCs. All of us read SCC, and you present the law as you see it. You can even present the law as you want it to be, but you cannot lie. You cannot manipulate the record. That's my answer to you.
Okay, thank you, ma'am. Thank you for your kind words. Now I'll give the forum over to Ria so that she can wind up.
So here we are at the end of the seminar. I, on the behalf of the entire team of the Lawsters, extend a very hearty vote of thanks to Indira ma'am and Nanita ma'am for gracing our event. We are grateful to you for sharing with us your findings and opinions today. Your experience and knowledge has given us all greater understanding of the values of this profession, especially in this time where most of us are just beginning and not willing to establish ourselves. Your idea of righteousness not only provide us to an insight we never had before and also motivate us to an authentic true to the legal values in the years to come. I also thank all my participants for joining us today and making this event a success. We hope that you continue to be a part of the Losters family and join us in the future events or the webinars we have in the future. And I hope that we can see you all there. Thank you. Until
Thank you very much.
stay home and stay safe. And see you next time.
Thank
Thank you so
you
much.
very much.
Thank you, Losters.
Thank you, ma'am. Thank you.